morning. This is Rich Sierra, CEO of the Florida Small Business Legal Center. This is episode number 51 of Business SOS. We're very excited that we're getting close to that 1 year mark. I'm very proud of that. It's been really an exciting year. And in the next episode, I'll talk about some of the highlights of last year and really reflect on last year's, this year's, the number of podcasts that I've done and some of the guests that we've had. So I'm very excited for that show. As I always begin the show, I'd like you to send me an email if you want to have a legal question, participate in the show. This is for you. You can send me an email at richsierra.com. Send me a legal question, anything you would like me to address in the show, and I'm happy to address it. And if I select your question, then you'll get a free copy of my book, Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them. It is available on Amazon, Barnes & Noble. You can ask for it at your local bookstore. You also can find me, if you have any information about me, you can find me at Florida Small Business Legal Center. The last few episodes, I talked more about specific topics like employment agreements, independent contractor agreements. Last week, I spoke about the new FTC rule banning non-compete agreements nationwide. And so today I want to go back to some of the basics that made me begin this podcast in the first place, is to really share with you some of the common mistakes that business owners make and are continue to make from the legal perspective and how to avoid them. And today I'm going to talk about 5 fatal mistakes business owners make in litigation and contracts. And why do I call them fatal mistakes? Because these mistakes can cost you, your business. This mistake can cost you a lawsuit. And they're, for the most part, avoidable. They are avoidable mistakes. They are what I call unforced errors, both in contracting and in litigation. So I want to talk about some of these. They have happened. There's situations that I encountered in my practice, and some of these have happened in the last few months. And obviously, I'm not going to provide specific details, but I want to share this with you because these are situations that are avoidable, and they just don't need to happen. And by going in that direction, you end up in a situation that are worse off than if you would not made the mistake in the first place. And I'll give you some specific examples. And I'm going to start with contracting. Now with, with ChatGPT and with a lot of access to AI, and we had this, also before that, we even had templates online. It is very common for business owners to download templates from the web for contracts. And full disclosure, we also use templates. I mean, we have legal libraries with contracts that we use as a basic to begin the process of contracting. So not everything that we do begins from scratch. It's just does not. It's, nowadays there's enough technology, enough of a knowledge base, if you will, that we're able to draw from that. And if you have experience, you've done these, contracts in the past, so you have the ability to draw from prior contracts you've written and drafted, and then you begin to adapt them to your client's needs. Okay, so in order to save money, many business owners go online and download forms from the web, and there's some number of services out there that provide that service. And I'm not mentioning anyone. I don't want to talk negatively about any company. Some of them provide good templates, which are a good starting point. And I want to repeat, contract templates are a good starting point. They're not necessarily a contract that will satisfy your needs or will satisfy what you're looking for, will meet the requirements of the contract. But they're a good starting point. They give you the template, the bullet points, they give you some language to work with. So what happens is that in order to save money, the business owner basically decides to download this contract, and they don't read the provisions carefully. And it looks good. Well, I'm going to send it out and sign it. And, or they begin to cut and paste from different free, sources on the web and begin to create this Frankenstein of contract. And then that becomes the basis of a asset purchase agreement. It becomes the basis of a joint venture agreement, becomes the basis of a vendor agreement, independent contractor agreement, you name it. And what happens then is, when that contract is breached by one party or the other, That's when the business owner calls me or calls another attorney. And the first thing that I asked is, said, do you have a contract? And say, yeah, we have a contract. I signed. I said, let me take a look at the contract. So when I look at the contract, look at the terms, and I'm like, obviously I can recognize the contract when it's drafted by an attorney, when it's not. So, and even if it has legal terms, I have a pretty good idea whether the contract was drafted by an attorney or the contract came from the web, or it was, something that the client prepared him or herself. So I asked the question, who prepared the contract? But I got it from the web. I kind of put something together, did it myself. And I said, okay, many people do that. In some cases, the contract is good, but unfortunately not good enough. You're not going to be able to, if you're not an attorney who has experience drafting contracts, you're not going to be able to develop a contract at the same level of expertise that an attorney with experience would be able to do. It's just a fact. Likewise, depending what profession you're in, we're not going to be able to do the work that you do with the same profession expertise that you do it, simply because that's what you do every day. So that's what professionals are for. And again, that's the basis for my book. So what mistakes, what could happen in a contract that you download from the web? And I just give you an example. A few weeks ago, I spoke with a client that somebody breached the joint venture agreement. And I looked at it and I'm like, okay, listen, what happened here? And, the contract was obviously breached. And I said, okay, so if you have heard me before, one of the things first thing that I look for is the jurisdiction of the court, or the jurisdiction section of the contract, and also whether or not it has a dispute resolution clause. And dispute resolution means if we have a controversy, we have a dispute within this contract, then we will agree to resolve it in this fashion. And in some cases, we're going to use we agree to, it'll be done in circuit court with the jurisdiction of venue in Palm Beach County, Florida. I'm using that as an example. In other cases, because other contracts have these provision, it might have an arbitration clause. And this particular one had the arbitration that any controversies we agree to have that will be resolved exclusively through the American Arbitration Association, their commercial rules. And it's fine, nothing wrong with that clause in and of itself. So, and I said, okay, listen, I see there's an arbitration clause here. Okay, do you know what arbitration is? The answer was no. Do you know what is the American Arbitration Association? And the answer was no. And I said, well, why did you include this section in this contract? They said, no, I just came from another contract. It sounded good. I put it in there. I said, fine. There's nothing wrong with the clause, but now what we need to do is go to that website and find out what it will cost you to submit a claim through the AAA, as we commonly mention it. So I said, what is the amount that you will be seeking on this contract? And the amount was, $2 million. So I said, okay, there's a range here. Did you know that, when you hire a AAA, there are case management fees, and you're in essence hiring a private court to handle this for you? I didn't know. So, well, let's go through the chart. Let's go through the fee schedule. And we find out that in order for this particular example, the fee alone, just to get into AAA, will be an exit of and I'm using this, now I don't have it in front of me, but it was over $10,000 just to bring this to AAA. And that does not include the deposit you'll have to put in for the arbitrator, which will be another $5,000. The arbitrator will have to be paid separately. So you're looking at, before you even begin a claim, you already have to put $15,000 aside, and that does not include your attorney's fees to prepare the documents and prepare the claim. So, and contrast that with circuit court. Circuit court, your filing fees in Florida is $401, and you add, a few $100s for service of process, depending on the defendants are and where they are located at. So look at the cost difference. Again, there's nothing wrong with selecting one or the other, but what is important is to know why you're selecting that option. And this was something that was self-inflicted. It's not something that was imposed upon the client, that he chose this claim. It sounded good, without understanding that you're hiring a private court to do so. So if I was to file a lawsuit against the defendant for breach of contract, then when I include the contract, say I file it in circuit court in Palm Beach County, a defense counsel will look at the contract and say, well, that's fine. We'll move to dismiss on the basis that has to go to arbitration or move to stay. So you're not going to get past the circuit court unless the opposing counsel does not catch that and answers the complaint. But for the most part, a competent business attorney will read that and say, this is not going to go anywhere. Again, this was a self-inflicted wound. So, you created an obstacle for your own contract and how to enforce it. And I have mentioned this before, that your contract is only as good as your ability to enforce it. If you do not have the resources to enforce a contract, you must well don't even have one. And I'm just keeping it real here. Many people, whoever has the resources, unfortunately has the ability to breach the contract, get away with it. And I mentioned that to my clients. I mentioned that to people coming in. Okay, you know what? I have a contract. If not, I'll sue them. And I'm like, okay, do you have money to sue them? Not really. And I'm like, well, you got to have more protections then, because if you cannot enforce this contract, it's going nowhere. So that's enough. I spent a lot more time than I wanted to on the contract issue, but you get my point. If the contract is important to you, you're going to receive money as a result of this contract. You're going to receive revenue from this contract, whether it's going to be a promissory note, whether it's going to be a joint venture agreement, whether it's going to be an asset purchase agreement, licensing agreement. Okay. If it's an important contract for you, for your business, you're better off going with an attorney than doing it yourself. You'll pay at the beginning some money, but in the back end, you're going to be more relaxed and you're going to be in a better shape. So moving on to number 2, filing lawsuits pro se. Pro se is basically on your own. So again, many business owners have corporations or LLCs. And in Florida, you have to have an attorney to file or defend a lawsuit other than small claims. So if you're a business owner and you're getting sued, don't go ahead and answer the lawsuit yourself on behalf of the company. The pleading will be stricken. You can even be held in sanctions. The same thing. If you are a business owner and you have an LLC or corporation, you're just a proprietor, you can do it. It's still not a good idea, but you still can do it if you're a sole proprietorship. But if you have a corporation, LLC, you cannot file a lawsuit in county court, anything above small claims, without an attorney. You file it, then what's going to happen is that the other side is going to file a motion to dismiss because it'll be a nullity. You cannot file it. The corporate entity must be represented by an attorney. And I'm repeating that several times because it has come up more than once in my practice in the last few months. And then what happens is that you can be held, you can end up paying the attorney's fees of the defendant by filing that lawsuit, because they were forced to defend a lawsuit that should have never been filed in the first place. Again, it's an enforced error that could have been avoided. It'll cost you money. Then you got to hire an attorney to fix it. Okay. Another error, and I want to talk about this a little bit, is not paying your attorney. And there's a misconception. Attorneys make a lot of money and they're wealthy. It's not the case. We're small business owners just like you are. And one of the things that the relationship with the client and the attorney has to be on the same page. And we understand that legal services are expensive, especially for small businesses. I mean, business owners are on their own. You're on your own. And I think I've written about this in prior articles in the past. There's very few financing options for business owners for legal services. Through our practice and through my office, I've been able to access some companies that do offer financing for legal services. But it's not something, it took a while to find them. And many of our clients have taken advantage of that. But for whatever reason, the banks and many finance companies do not offer financing for legal services the same way you can get financing to go on vacation. Don't know why. It's just a different conversation altogether to be had. But you are on your own. So when you have to pay legal services. I recognize that you have to pay them out of your own savings, out of your own revenue, or a credit card. I mean, those are the three options that you have. But because there's not, another funding source that will allow you to take care of that. So you got to have a conversation with the attorney about what you can afford to solve this problem, what type of litigation budget you have to be able to solve the problem and how far it can get you. And litigation, as I mentioned before, is an adversarial process. If you cannot afford it, tell the attorney whether they can put you in a monthly payment plan. But when you don't pay the attorney already has incurred expenses. There's paralegal, there's an infrastructure in place. There's answering services. There's a lot of things that goes on, plus the attorney's time and effort and office expenses. So when you do not pay the attorney, then obviously the attorney, that's a red flag for the attorney. So, well, I'm working in this case. Well, the attorney would kind of be able to continue providing financing this case for the long haul. So not paying the attorney, what happens is the attorney makes a phone call, talks to you, and it becomes more of a chase for the money. And then you can have the attorney then suspend services and eventually withdraw. But if you're in a situation that there's an attorney bill that is coming to you, you cannot pay it, just call, say, listen, this is what's happening. Can I split this in half? Can I work with you on this? Communication makes a difference. Not paying it is just not a good option, because then you're going to end up not having an attorney. Then you got to find another one. They're going to ask you what happened. You're going to be in a cycle. But having that communication is very important, but it's a fatal mistake, because you can end up not having an attorney for your legal problem. On the same note, this is B number 4, not meeting discovery deadlines, and also not being available for the attorney when the attorney asks you for a phone call or for a meeting. You hire the attorney to help you with your case. So discovery is request for production of documents, request for interrogatories, request for admissions that are commonly exchanged between the parties in the litigation. In interrogatories, I went into a deeper dive regarding discovery a few weeks ago. Interrogatories are questions you need to answer under oath. Productions requests are documents you got to produce pursuant to a request that they ask you, documents that are relevant to a litigation. It could be a list of 5 or a list of 100. But you have to go through that list with your attorney. And usually have 30 days to provide them. It's good not to wait till the last day. You should be working on those pretty much immediately, so that way you don't miss the deadline. And also request for admissions, whether you admit or deny the allegations, and they give you a list. When the attorney sends that to you, usually a paralegal handles that, sends that request to you, tells you, listen, we need to get this in a week so we can start preparing the responses. Let me talk about interrogatories. Interrogatory questions are under oath, obviously, so there have to be truthful answers, but obviously have to be carefully drafted. Whatever answers you have, usually the paralegal begins to work on that draft, goes to the attorney reviews them, there's some clarifications that have to be made, The attorney will clarify those and then goes back to you, say, take a look at this. Is this accurate? This is correct. So it's a drafting process. It's not just, write a couple of answers and send them out and get it notarized. No. For your benefit, you want to make sure those interrogatory answers are done correctly and done accurately, because in a deposition, you're going to be asked regarding those answers that you provided. So this is a process. That's why you have 30 days, not just to wait till the last minute. So the attorney said, and the same thing with document request. You send those documents. It's what we have. It's going to take me some time to do it. Well, it is your case. You got to provide the documents. But providing them to the attorney, then the paralegal has to organize it, has to classify which document is responsive to which request. Sometimes they're repetitive. Those documents have to be PDFs. And they also have to be Bates numbered. So there's a lot of organization has to be go through in order to provide the documents to opposing counsel, but it's also good for us to have them organized because we'll be using those documents at trial. Request for admissions, the same thing. You go through those. If they're obvious denials, they're denials. If they're admissions, they're admissions. Those have to be reviewed by the attorney before they actually go out. So a common mistake that some business owners make is that this is sent to the client, and the paralegal is trying to make appointments with the clients. Listen, let's set up an hour so we can begin drafting these answers so the attorney can go ahead and get them reviewed on time and get them to the opposing counsel. No response. Do another follow-up. No response. So we're getting close to deadline, so the attorney has to basically file a motion for extension of time to respond to the discovery. I don't like filing those motions unless absolutely necessary. If the client's out of town, there's a compelling reason why the client cannot meet the deadline. Obviously, we'll file it. Sometimes the attorney is obviously traveling or something not available, but usually I don't like filing those if I don't have to. I'd rather meet the deadline and move on, because also you're asking a favor to opposing counsel. Can I have an extension? And you obviously got to reciprocate if that happens to them as well. Okay, so not meeting discovery deadlines are important. It's a fatal error because it can cost you your case. Also, not being available to the attorney for meetings, for phone calls, for preparation meetings, like when you have a deposition, it is common to have a deposition prep with the attorney. Same thing with a mediation, same thing with trial. So those meetings are important. Remember, you hire the attorney to help you. And the attorney you're not the only case within the attorney's file, attorney's caseload. And we all have the same amount of time. We have the same amount of time, the 7 days a week, work 5. So when the attorney says, I need to speak with you for an hour about this matter, do make your best effort to be available to the attorney to be able to address your issues and answer your questions, and also make the appointment. Because at that time slot it's available for you, you cancel at the last minute, or you have no show, that time can never be recovered again. Time is gone. So obviously the attorney will find something to do, but the attorney prepare for that meeting before you actually get in the phone, before you get in the Zoom call. So then, that actually costs you money because that preparation time has to be paid. And I remember that I went to a mediation. This was like close to 15 years ago. And I remember this mediator said that all attorneys are smart. To be able to get through law school, you got to be smart. But the attorney that wins cases is not the smart lawyer. Is the most prepared lawyer. And preparation costs money. So I want you to keep that in mind, that the time for preparation is essential to your case. And your availability, your disposition, and your cooperation is essential for the attorney to be able to do his or her job. So, but not being available, not cooperating, it's just not going to help your case. last but not least is not following your lawyer's recommendation. This is kind of combining it two, and it's number 5, but it's basically 2 of them, but it's the same topic. Not following your lawyer's recommendations or trying to be co-counsel by bringing up cases you find on the web. It's happening more often now because people have access to ChatGPT. And I'm smiling simply because it's a bit comical to me, and with respect to the access to information and what people are trying to do. And but let me talk about not following your lawyer's recommendations. When you hire an attorney, especially in business litigation context, okay, it's about strategy and tactics. It is about how to find a solution to your legal problem. And it's part of an art, part of science. It is not that clear cut. So the creativity comes into play, the experience of the attorney comes into play, and the knowledge of the attorney and the ability of the attorney to negotiate comes into play. We see things from a perspective that you might not see it. We're here as your advocates. We're not in the same position. You're the client. So there's sometimes the recommendations are not followed, and it becomes more of a tug of war between the client and the attorney. It happens to all of us. And that's fine. That tension is sometimes healthy simply because we try to come up with a solution and we try to understand how to solve it. But not following directions, not following the recommendations, if it happens very often, then the relationship is not going to work. Because every attorney is different. We have access to the same law. We have to the same cases. It's how we utilize all the tools that we have creatively to solve your problem. That's what sets us apart. That's the difference. And the recommendation that we provide is based on the years of experience that we have and the hundreds of cases that we've managed to be able to come up with a solution for you. And sometimes might take 2 or 3 steps. So, listening to the recommendation, understanding it, but then having a game plan that let's follow through with this recommendation, let's go forward. It's important. But also, once the decision is made in the recommendation and the attorney acts upon your recommendation, it's important that once that decision is made and you go forward, if you change your mind after the decision is made, it could be an issue. Because then you have to go back to opposing counsel and say there was a change. So from a business litigation standpoint, we're looking for mistakes on the opposing side. We're looking for openings. And I hate to say that it's kind of a game, but it is a game. There's gamemanship here in litigation. So any mistakes, anything we can capitalize on and vice versa, it is fair game. Any tension that can be created between the client and opposing counsel, it is fair game, provided that is perhaps a fact that was not disclosed. Anything. So you have to be on the same page with your attorney, understanding what the strategy and tactics are. As I mentioned before, you as the client, you're not co-counsel. And I make it very clear to my clients. Okay, I appreciate your input. I appreciate you providing this information. I got this. Okay, I have attorneys that can help me out, that have experience in this matter. But I decline, you as the client, you're not going to be second chair to your case. You should not be second chair to your case. Let the attorney handle it. Let the attorney handle it because everybody does things a little bit different. Everybody has their own style. Everybody has their own gifts. And we do this every single day. So allowing the attorney kind of do his or her own job is going to free up your mind. But trying to second guess the attorney and going through cases that you found on the web, just to try to analyze it, and then we spend a lot of time talking about things that are not going to go anywhere. So just keep that in mind. Okay. Obviously, if you have disagreements, you're not happy with your attorney, change it. You can fire the attorney at any time. Nobody's obligating you to keep the attorney. But once you hire the attorney, give him or her the freedom to do the job that you hire him to do. And you're going to be very happy with it. And obviously, you have concerns, bring it up. Open communication is very important to have a healthy attorney-client relationship. So I hope this was helpful to you. And again, just to recap, and these are the five fatal mistakes business owners make in litigation and contracts. And obviously, you want to avoid them. Downloading contracts on the web and utilizing them in your business without an attorney reviewing them. Filing lawsuits on your own, what we call pro se, P-R-O-S-E. Not paying the attorney. Not meeting discovery deadlines, or not being available for the attorney when the attorney asks you for a phone call, for any meeting, for an email. Not replying to emails as well, that includes that. Not following your attorney's recommendation, or trying to be co-counsel by bringing up cases you found on the web. So those are the 5 ones. I think this is good for now. I hope this was helpful to you. If you're in a situation that you're in a litigation, you have the desire to go on your own and do something on your own, my recommendation is pick up the phone, call an attorney, have an attorney help you with this, so that way it'll free up your mind and you can go and run in your business. That's the best option. That's what basically the basis for this podcast, the basis of my book, Business SOS. So if you want to reach me, you have any comments on what I talked about, you can send me an email at rich@richsierra.com. My website is floridasmallbusinesslegalcenter.com. You want to give us a call. My number is 866-842-5202. Remember that Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them. It's available on Amazon, Barnes & Noble. You can ask for your local bookstores. If you like the podcast, please follow us. Give us a 5-star review. That helps the algorithm, recommend this to other business owners. Share this podcast as well. We're available on Apple Podcasts, Spotify, wherever you listen to your shows. Until next week, this is Rich Sierra. Remember that my goal is to help you succeed.